Good afternoon and welcome to the breakout session on individual clients. My name is Marianne Pisarri. I'm a partner in the DC law firm of Pickard, Djinis, and Pisarri. My practice focuses on issues regarding investment advisors, broker-dealers, NRSROs, and service providers to the financial industry. We've got a great panel today: Julius Leiman-Carbia, David Wong, and Joelle Sims, and I'll ask each to introduce himself or herself.
So I'm Julius Leiman-Carbia. I am the Chief Legal Officer of Wealthfront Corporation. Wealthfront has a registered investment advisor and a broker-dealer. My experience is broad and diverse. I was Chief Compliance Officer for broker-dealer and retail services at JP Morgan before this. I also was at Citi and Goldman, in addition to other stints with commodity houses and et cetera. But I'm pleased to be here. Thank you very much, Marianne.
David?
Hi, I'm David Wong. I'm the CFO and CCO of Private Wealth Partners. We're a registered investment advisor. We're not a broker-dealer. We manage about $1.5 billion of clients' assets, separately managed accounts only, no institutional money at all. And I've been in this business for 15 years. Prior to that, I was in venture capital, private equity. Originally from the UK, chartered accountant, so my background is really as an accountant. So be dealing with hedge funds and also with mutual funds, offshore mutual funds. And glad to be here.
Hi everyone, good afternoon. My name is Joelle Sims. I'm a principal with the law firm of Bressler, Amery, and Ross. I am based in our Dallas, Texas office, though formerly from and still work out of our Fort Lauderdale, Florida office as well. My practice focuses primarily on representing financial institutions, registered representatives, investment advisors in litigation matters and regulatory matters. I also do some commercial and employment work as well, and I am co-manager of our firm's senior and vulnerable investor group. So looking forward to discussing with all of you, to hearing your questions, hearing my fellow panelists, and thanks for having me.
Thank you, Joelle. So, as you've heard throughout this conference, issues relating to individual or retail clients are front and center in the regulators' minds. We heard from Pete Driscoll yesterday, the leader of the band formerly known as OC, now the Division of Examinations, that the 2021 exam priorities are going to continue to focus on retail clients, senior investors, and investors saving for retirement. We also heard in the ERISA section that the Labor Department is still focused on the fiduciary implications of retirement plan rollover recommendations. So individual, senior, retail clients are very much a hot topic. We've got a lot to cover in this space, so we've curated the, we've curated the material that we're going to cover for you today. But I invite you to check out the supplemental outline that's provided in your course materials. And there are some additional resources at the end of these slides that I think you'll find very helpful. And I'd also like to invite you to submit questions as we go along in this presentation. To the extent time allows, we'll be answering questions as we go along. And a little bit of housekeeping for those of you who are tracking codes for CLE. The first code for this presentation is the word retail. All right, so what we're going to do today is we're going to walk through the life cycle of serving an individual client. And then we're going to spend some time digging into special issues that arise with senior clients, and then also on the other end of the spectrum, issues that deal with brand new investors. So we're basically going to do a boomers to zoomers survey here. And I'd like to set the stage by noting that everything that we're going to be talking about derives from the basic fiduciary duties of care and loyalty that an advisor owes to all clients, institutional and retail. And although the principles, the fiduciary principles apply across the board, there are specific instances and specific issues that arise with clients. It's an adaptable principles-based regime, but you have to always be on the lookout for where the fiduciary duties require you to do something different for the retail client. And some of those different obligations are reflected in specific SEC rules. So let's start with our life cycle. The first thing, onboarding the individual client. You can't onboard a client unless you attract the client to your business. And that obviously invokes or involves marketing. There is going to be a session later this afternoon on the SEC's new marketing rule. I certainly hope everybody is planning to attend that. It's big stuff. The marketing rule was published in the Federal Register today, which means the 60-day effectiveness clock has started to run. We're not going to go through the marketing rule in any kind of detail here, but I do want to point out that there are at least 3 aspects of the new marketing rule that specifically address the retail clientele. The first is in the general prohibitions, anti-fraud prohibitions against false and misleading statements, and an obligation to convey information in a fair and balanced manner. That is scaled to the audience. So what is fair and balanced, what is misleading for an institutional client is going to be different from a retail client. So keep that in mind as you navigate the new marketing rule. The second aspect of the new marketing rule is a good one, and that is that the SEC has finally gotten rid of the decades-old prohibition against testimonials. So where you're marketing, especially a younger clientele, that gets advice on the internet, social media, Yelp, et cetera, you will no longer be hobbled by a prohibition on using testimonials. However, the SEC giveth and the SEC taketh away. There are a lot of restrictions and conditions to using testimonials. The third area and the last area has to do with the display of hypothetical performance. And there you'll hear in the panel this afternoon, the SEC has special protections that they want to see for hypothetical performance. And in fact, depending upon who the clientele is, you may not be able to use hypothetical results with a retail client. So that's a real quick and dirty on marketing. The next thing you have to do when you're onboarding the client is figure out who the client is, what the client's investment objectives are, what the financial situation is. Now, this obviously, again, goes back to the fiduciary duty of care. You have to act in the best interest of the client. You can't do that if you don't know the details about the client. Where you have an institutional client, they push information to you. They have an information policy statement. They have a lot more detail that they provide you. But for the retail client, you really have to go out and make an effort to get the information that you're going to need. One thing, and I'm going to turn it over to David here, one thing is what types of obligations you may have to a client before the client actually signs up. David, would you like to take a crack at this?
Yeah, sure, absolutely. So probably what I'd like to do is present to you perhaps the more practical areas of providing advice to prospective clients from a aspect of ourselves as an RAA, and essentially there are some slight complexities to this, and we have, obviously, under the Investment Advisors Act, we have a fiduciary duty. The anti-fraud provisions of Section 206 applies as to how we basically talk to our prospective clients and what information we provide with them, particularly when you're making decisions about investments for clients who are not clients yet. And that kind of morphs over to one special area, which is to do with retirement accounts, which are governed by the Department of Labor and ERISA rules. And that becomes problematic because under ERISA laws, you are deemed to be a fiduciary even before you engage a client legally. So therefore, that adds some complexities. Now, the thing is one of the things about some clients who say, "Oh, can you manage my IRA? Can you manage my 401k? What do I do about it?" And there's been quite a lot of talk about this and written language that you can find. But essentially, one area which you can actually sort of, I wouldn't say bypass, but get yourself exempted from this, is that if the client has made the decision to hire you, this hire me clause in respect that, just manage my IRA. And we have lots of examples of this. We've had clients who say, look, we're going to be managing my trust or my revocable trust and my family account. Why don't you just take all my, my rollover, my SEPA, et cetera, as well? And in that case, you don't have to go through the whole sort of recommended checklist of finding out exactly what's in their account, in their IRA account, what kind of investments they have, what recommendations you're going to give, because there's quite a lot of work involved with that. So unless it's like a hire me sort of clause by the client, or it's essentially like, an education, one of the things is that most of our clients have said, look, just manage my account. I've already done the homework. I've already done my due diligence. I don't need any more. There's just and the best way to do about this practically is document all of this, right? So you need to have documentation with a client, an acknowledgement, preferably in writing, that the client has made the decisions to basically appoint us as their advisor, the discretionary advisor to their retirement plan, whatever it is, or they're going to convert it. They've made that decision already, and we're going to just manage a rollover IRA for them. And that's perhaps the best practical solution. Otherwise, you're going to have to go through, several steps of, looking at the fee structures and providing the best, what they call the impartial conduct standards of the rules in ERISA to basically apply to make sure that, they are reasonable compensation. They're not making we're not making misleading statements, etc. And so to do all of that, particularly if you're a small advisor, which we are, it's quite a lot of work, and it's quite a lot. So that's what I'd say is perhaps the practical advice I can give you as to how to go about this. But for most clients, KYC, know your client and know your prospective client first, and find, obviously the client investment guidelines is the other area. Make sure that those are well documented so that you know the risk tolerance, etc., and investment types that you need to apply for those clients going forward.
Thanks, David. And I will recommend, if the audience wants to know about the types of information that you have to have when you're making the recommendation about a rollover, check out the materials that went along with the ERISA panel 2 days ago, the IAA's checklist, which is enough to make anybody blanch. That is there. It's an excellent tool, but you realize it's a daunting task to actually come up with all that information, as David noted. All right, so you've done all that, and the client, you actually have the client now. Let's spend just a couple of minutes talking about the client contract. One thing to note, the Advisors Act does not require an advisor to use a written contract. However, a well-written investment advisory agreement is a wonderful risk management tool, and really, it's such a good idea. You really have to have a good reason not to use a written contract. One of the things the SEC said in the 2019 fiduciary interpretive guidance is that when they talked about the fiduciary duty, they said the fiduciary duty cannot be waived. However, the contours of the fiduciary duty can be spelled out in writing. So the contract, a written contract, is a good place to scope out what it is your fiduciary duty is going to entail. Spell out the services you're going to provide. Equally important, spell out the services you're not going to provide. If you're not doing any tax management, you're not voting proxies, you're not monitoring class actions, spell that out. The other thing, the SEC, the fiduciary duty of care entails a duty to ongoing monitoring of the managed portfolio. The SEC says the frequency and timing of the ongoing account monitoring is a material fact that should be disclosed to the contract or to the client, and the contract is an ideal place to make that disclosure. In addition to defining the contours of the fiduciary duty, the contract is a great place to manage expectations. And for years, advisors had used what we call hedge clauses, where you say the advisor is not responsible for anything other than gross negligence or intentional misconduct. And because the fiduciary duty can't be waived, and because rights under the federal securities laws, the Advisors Act, can't be waived, advisors always have a savings clause, but nothing herein means that the client is waiving any statutory rights. In the 2019 fiduciary release, the SEC said where you have a retail client, you really shouldn't be using a hedge clause, even if you say to the client, you're not waiving non-waivable rights, because the client is likely to be misled and confused. So if you have to take the hedge clauses or the limitation of liability clauses out of the contract, what do? Well, you can put in no guarantee. The advisor is not guaranteeing that any result will be achieved through the management of the account. You can put in a reminder of risk, that all investing entails a risk of loss. And so there are things you can do, but you should be aware of the SEC's guidance on this and ways that you can potentially get around the guidance. So what else might you want to put in your advisory contract? David, would you like to talk about trusted contacts?
Absolutely, absolutely. So a few years ago, we amended our advisory contract template to include a page of trusted contacts so that the client could basically put in who they felt was basically best for the advisor like us to contact. And you have to remind yourself that the trusted contact doesn't have any authority to really act, but it's really somebody that you can contact to make sure that this client is okay, that something isn't going on. And what we also did was that we actually went and amended all our existing contracts. So we added an addendum. So essentially, we went back to all of our existing client contracts and we sent around to all our existing clients an addendum saying, please give us your trusted contacts. This will be added to your agreement. And then we've got a program now where we kind of look at it every couple of years to make sure that this information is current, because what if the client has a falling out with this trusted contact? Most trusted contacts are usually like their spouses, their children, a relative or so forth. It could be even their CPA or somebody, a friend. So, and sometimes clients will forget about that, or the person's left or have passed on. And so it's kind of important, because when we come to talk about the whole senior client aspect later on in these slides, you'll realize that this is kind of an important aspect in basic, not just onboarding your clients, but also reviewing your clients' contracts, every sort of like period during the lifetime of the client that is with you. We've got clients that go back over 25 years, and I think it's important every few years to go back and look at your agreements and see, well, are they still current? Are they still valid? Is there something in here that we need to basically update? And that's kind of important to the whole role of retail clients.
Okay, so we're going to move on. Now you've got the client. You've done with the contract. What types of things are you thinking about as you go forward managing the account? David?
Yes. So in terms of advising clients and this duty of care, one of the things that we always have in place, which is part of the advisor contract, is a client investment guideline. And the client investment guideline is basically a document which is prepared together with the client which basically talks about the holistically the risk tolerance. What other assets do they have that they may rely on or not rely on? What are their liabilities? What are their obligations in terms of? It's almost like a little bit like financial planning in a way, but it kind of gives an overall picture of the client, the family, the history, and so forth. And when you get to know this client, then you begin to be able to design a program, an investment program, whatever it is that you have in their best interest, okay? And essentially, this client investment guideline is usually formulated between the relationship manager of the firm and the portfolio manager and the clients, and obviously the operational staff. And it's very important to try and, again, like the advisory agreement, review this every couple of 2 or 3 years, because clients' circumstances change, right? They get married, they get divorced, they have kids, they got to plan for colleges, they're about to retire from the workforce and things like that. So, and that impacts obviously their risk tolerance, their investment sort of life cycle, so to speak, and you may have to change the investment program for them. Going from maybe a high growth sort of portfolio to a more balanced portfolio for an income portfolio for a person who now relies purely on their portfolio for income purposes. So the life cycle of a client in a relationship is to my mind, kind of for quite a long period of time, depending where the client is in their life cycle stage of their investments and their financial circumstance. So in a sense, you're kind of a financial guardian for your clients, and that's how we've kind of tried to present ourselves, in the sense that being a financial guardian for your client is really, in a way, trying to act in your client's best interest and obviously behaving as a fiduciary to your client's needs and wants.
Thank you. Excellent. So let's move now. You talked about the life cycle of the client. Let's talk about a client who's toward the end of his or her investment cycle, and that is the senior client. Joelle, what can you tell us about Senior Safe?
Sure. So there are a number of statutory considerations. The one applying to everybody is obviously the Senior Safe Act, which is federal law that was signed in by President Trump. It provides limited immunity from liability to advisors and their supervised persons for disclosing suspected financial exploitation, and it applies to people 65 and older. The law encourages but does not require disclosure, and immunity is conditioned on training compliant with the Act. If we want to go to the next slide. So in terms of Senior Safe, and you could spend a long time going through all the nitty-gritty details of it, but essentially reports can be made to a wide variety of what they call covered agencies. These can be state financial regulatory agencies, federal agencies like the SEC, SROs like FINRA, law enforcement, adult protective services. Generally speaking, when you get to a state level, which we'll talk about in a moment, it typically is going to default to state securities securities agencies, as well as adult protective services. Now, in terms of training under the Act, it has to be provided as soon as reasonably practicable and within 1 year from the date of the employment or affiliation of the person with the financial institution. It has to instruct how to identify and report suspected exploitation. It has to address client privacy and integrity. So this is always kind of the competing concern in this. Is on the one hand, you want to protect the client and also protect the firm or the investment advisor, but you also want to make sure that you are protecting the client's privacy and integrity and not broadcasting details about their life that doesn't necessarily need to be broadcast. Also must be tailored to the job responsibilities of the employee. So if you're training somebody, for instance, if you're talking about a larger operation, if you're training somebody in compliance or in legal, that's going to be different than if you're training a client-facing employee, which is going to be different than if you're training somebody, who maybe does IT or that sort of thing. Let's go to the next slide. All right, so special considerations here getting into the state level. State adult protective services statutes, every single state has one of these. Most are broad enough to apply to financial exploitation. A lot of these are driven primarily towards physical exploitation, abuse, that sort of stuff. But every single state has one of those. What's been more recent and has just been evolving at a rapid clip here over the last couple of years are state financial exploitation statutes. There's currently 30 states and counting that have them. And what both of these types of statutes have in common is they protect persons 60 or 65 years and older, depends state to state. Some states are 60, some are 65. Also protects people 18 years and older who have diminished physical or mental capacity. And that's interesting depending on which state you're in, because some states, the language, really can kind of apply if somebody is sort of just having difficulty managing their finances. So it's important to look at the specific statutes. And of course, the criteria varies state to state depending on where your client is located. Let's go to the next slide, please. All right. So again, APS statutes, all states have laws, and this really has to do with APS and the financial exploitation statutes. All states have laws related to how and when to report elder abuse. Some states require reporting by everyone, other states permit reporting, and states have different protocols and timeframes for that reporting. And most of these states will have good faith reporting that triggers immunity from civil and criminal liability, meaning that if you make a report of suspected exploitation in good faith and have a basis to do it, they can't come back and sue you, either civilly or file criminal charges against you for making the report. Now, obviously, you get into other issues where you may be sued for other things, but you cannot be sued solely because you made the report if it's done in good faith. Let's go to the next slide, please. Okay, and here again, state financial regulation statutes required or permissive reporting, typically to the Adult Protective Services unit in that state, securities commissioner, or other agencies. There's permissive temporary holds of suspicious disbursements and or transactions. Most states are trending towards doing disbursements and transactions, but there are some that allow for disbursements only. So that means money going out. It doesn't mean a request to sell, a request to buy, so you want to be careful knowing what you're dealing with depending on which state your client is located in. Permissive third-party disclosures. This is huge. And it's super important. And one of the resources we included at the end of the slide and in the deck is our firm, Bressler, has a senior map. You can just Google Bressler senior map. It's also available through the IAA webpage, which basically you can click on any state. It will tell you everything you need to know. It'll tell you what the APS statute says. It'll tell you what the report and hold statute says. It'll have links to where you report, links to forms. It will tell you everything you need to know. But going back to what David was talking about with the trusted contact, I agree. I can't stress how important it is to get that on your accounts. Because in the vast majority of these situations, and we'll get into this in a little bit later, most of these agencies that you report to under the time periods of these statutes, you're not going to resolve the situation if there is truly exploitation or suspected diminished capacity. It's not going to get resolved in 20 days. It's not going to get resolved in 30 days. And so really, the best kind of outcome is to get the family involved and have them take the legal action. And the best cases are where you reach out to the daughter or son, they're the trusted contact, someone's trying to exploit mom or dad, they institute a guardianship proceeding, and then you've got a court order telling you to restrict the account until they give you further directions. And that way you're protected, you're relying on the court order, and you're not the one who's dealing with the decision, do I disperse this money or do I not? The time period that APS gave me has now expired, but this, new best friend is still seemingly exerting influence over the client. So again, I can't stress how important it is, and David definitely highlighted that, about getting a trusted contact. But sometimes you have
if I can,
go ahead.
Well, I was going to say, I'm sorry to interrupt. We have a question from the audience on trusted contacts. Is it advisable to rely on the trusted contact that the client lists in the custodian paperwork, or does the advisor have to have its own trusted contact form?
So I would say it depends. I think it's advisable to rely on that. Obviously, the exception to that being if you think that trusted contact is the one doing the exploiting, then obviously you don't want to, you don't want to call that person. But I think it depends. If the client has identified someone to you as a trusted contact, then yes, rely on that unless there's some reason to believe that that person is the one who's engaging in the exploitation. And, I would tell you, get multiple trusted contacts if you can. I mean, you don't have to go crazy and get like 10 of them, but if you can get 2 or 3, it's always good because, statistically speaking, we'll see this in one of the later slides, the most common perpetrators are family members. So if you've only got one and that's the person you think is doing the exploiting, then that puts you in a bit of a difficult position. But as to the permissive third-party disclosures, this is so important to know what you're dealing with in the state. There are, I would say, a good number of states, and I think it's becoming more common, who include in the statute that you may reach out to anyone who is reasonably associated with the vulnerable or elder adult. So that means you don't need to have the trusted contact. That means it doesn't matter if they gave you permission. You are statutorily allowed to reach out to someone who is reasonably associated if you believe that there is abuse or exploitation going on. And I'll give you an example. Texas is one of those states. So if there is no trusted contact on the file, you're allowed to contact, a relative, the kid. If there's nobody there like that, trust in the state attorney. Those are good resources. The CPA, that's another good resource. So really critically important, make sure you know what you're dealing with in the state the client is located in. A lot of these have required training provisions. And again, keep in mind that under these statutes, holds are allowed only where there is a senior and vulnerable investor and exploitation. It does not apply simply because you believe someone has diminished capacity. There could obviously be other reasons to place a hold if you think your client is lacking capacity, but it's not under these statutes.
Okay, well, let's move for a minute to diminished capacity. You've dealt with a client for a long time. You know the client, how the client normally behaves and what the client's normal preferences are. And over time, you start getting suspicious. David, what sign should you look for to say that somebody's dealing with diminished capacity?
Yeah. We've just put down here on this slide here some of the things that you should basically be sensitive to, and this is not an exhaustive list. In fact, there's a nice paper actually in the resources at the end of the slides, giving you much more details on this of what constitutes as disorientation, memory loss, things like that. But I think part of this, as Joelle says, is the training part of it is actually very important, because if you're dealing with clients and you're talking to them, you get to know them, it does become apparent that sometimes you will see a consistent pattern of dementia, right? That's one of the obvious things that may happen, or somebody may have the signs of beginnings of Alzheimer's and things like that. And so it isn't just like a one-off thing. I mean, a lot of us, I'm sure, like I do, forget to do things, right? I mean, that's normal. But when there's a consistent pattern of forgetting things, and you're talking with clients and they're now asking you about things or forgetting about things on a consistent pattern, then it should become like a yellow alert. And you should be not only just aware of it, maybe you should just write it down, make a note of it. We typically in our firm, when we have staff meetings, we talk about certain clients. We have a lot of senior clients. In fact, I'd say more than 50% of our clients are over the age of 65, because they've been with us for a long time. So because we've had a long history with our clients, we know what they're like. It's important that as you get to know them, you know their behaviors and what they do. And so these are just some of the sort of things that you will recognize and see. But it's also very important from a training aspect that your staff that deal with these clients, from either operational, from a relationship manager, when you structure training, to basically to get them to understand some of these signs that you'll see. Now, that's not to say you start acting on them, okay? You don't act, but you need to be, I think, sensitive to them, sensitive to what's going on.
All right, well, thank you. And moving along in the interest of time, so that's diminished capacity. What about vulnerability? What about people who are being targeted? Joelle?
Sure. So, and as I mentioned before, and you can see the breakdown here, the most common perpetrators are family members, and beyond that are people who are close to their victims or close to the vulnerable adults. And here is a breakdown of those. I think we can go to the next slide. One point I would mention is guardians and POAs, powers of attorney. Keep a special eye on that. And I've had this in a number of trainings I've done in the field, where just because somebody has legal authority to do something on the account doesn't mean that they're not exploiting someone. Those are two different things. Somebody can have legal authority like a guardian, but if they're engaging in abuse or exploiting the vulnerable adult, that's still exploitation that needs to be reported. And, if nothing is done, that's going to become a problem. So definitely keep an eye on guardianship accounts, on POAs, also on joint accounts too. If you have a joint account, for instance, with a parent and a child, just because they're authorized on the account, if all of a sudden, Junior's starting to take out more and more money and he's coming to the office in a Ferrari, keep an eye on that, because just because he's authorized doesn't mean that it's not exploitation. So red flags indicating possible exploitation: dramatic, unexplained shifts in investment style or unusual transactions. Big ones: sudden withdrawals or change in amount and frequency of withdrawals. Typically where there's exploitation, it's going to be more on the disbursement side. It can be securities related. There was actually a case in Texas where the TV repairman came to repair an older gentleman's TV, and all of a sudden was trading on his account, had access to the powers, fancied him to the account passwords, fancied himself a day trader. So it can happen on the transaction side, but typically where you're most often going to see this is large disbursements coming out. Request to transfer assets to suspicious parties or locations. Family, friends, new acquaintances who pay extraordinary interest in assets or belongings. And, I think when we think of this, we always sort of believe it's going to be an older person with a younger person. I had a case recently where there's a 79-year-old client, 2 weeks after his wife passed away, showed up with his new wife, who was 40 years old and was also his former deceased wife's home health care aide, and was now the new wife. So I think we kind of imagine that being the scenario, but it doesn't have to be someone younger. I had another case where there was an older gentleman, after several marriages, he rekindled, his old high school flame. And all of a sudden she started coming into all the portfolio reviews. All of a sudden, he had always been very dominant and she was taking over all the meetings. She was talking about our accounts when she wasn't listed. She was moving him out of his progressive living facility into a condo on the beach because she used to be a nurse, 4,000 years ago and can take better care of him than anyone else. So the point that I make with that is that it doesn't have to be someone younger. It can be someone who's also older, exploiting the older person. So if all of a sudden there's a new person who hasn't been around, pay attention to that. Of course, suspicious signatures on documents, abrupt changes in any sort of trustee, estate planning, beneficiary changes, things of that nature are things to keep an eye out for.
Okay, well, thank you. And we could spend a lot more time on this, but I think we're going to hop over to the other end of the spectrum, which is the new investor, the young investor. And Julius, what can you tell us about the special challenges of dealing with this kind of investor?
So just to give a background, there is an ongoing generational change in the investment community in terms of the type of clients, right? So clients increasingly, there's been transfer of wealth from the sort of boomer generation to the X generation and then to Z generation and so on. And this is a new generation that is a lot more proficient with technology. And in fact, would prefer all communications with technology. That's a generalization, but it is fair to say that a lot of them, in fact, we have encountered that many of them do not want to be called. They don't want a human being talking to them. They would prefer to get information through social media, get information through emails in a way in which they can pay attention whenever they want. And that's the dispositive factor, right? They don't want people talking to them. They want to choose when they pay attention to issues, which presents a different set of challenges, right? Because social media, as well as electronic communications, require a certain amount of it's interactive, and it's limited by space, and it's limited by the circumstances in which it is presented. So to be very clear, I mean, there are going to be some, and I'm going to talk about this. How do you actually deal? How do you communicate, and how do you exercise your fiduciary duties when the way you can communicate is very limited? So one of the ways we do this is through social media, right? And by social media now, I'm referring to Twitter, Facebook, platforms such as those, which of course are not platforms that most of the regulation, definitely not the law, contemplated at the time of its creation. And so one important thing to know is that because of, consistent with the way in which the law sees the platform, we are not, the advisor is not responsible for what is on that platform. So if someone comes in and says, on your webpage says something, so long as you don't edit the content, you don't select, you don't prefer certain comments over others, you're not going to be responsible as an advisor. And that's a significant point. Yeah. Go ahead.
I'm sorry to interrupt. If you look at the adopting release on the new marketing rule, the SEC has a section on social media and what their views are, and it's exactly what Julius is talking about. So that is of the moment. It's a completely hot off the press confirmation of what you're saying, Julius. Sorry to interrupt.
Yeah, well, and actually it's a little bit of a change, because in the past, the commission had taken the view, had not taken a clear view, and in some cases had raised issues. If it was on your platform, are you endorsing it? I don't know that there was any successful prosecution or anything, but I know that at some point there was a discussion, an active discussion around this. But the important thing here is, because look, it's clear that sometimes, and this presents a challenge, because sometimes social media is not controlled, as we all know, and some clients or other people may say things that may be problematic. It may be vulgar, violent, or even misleading. And so, generally speaking, people, the advisor or anyone who's responsible for the platform, may feel tempted to order things or delete certain things. There is going to be a gray line. If you're deleting something that is violent, well, of course, I think that will be okay. But if now you're choosing to put at the end of the platform the negative comments and only highlight the positive comments, I think the SEC is going to have a little problem with that. So moving to the next, it's important to know that as I mentioned before, the generational change is not only with respect to clients, it's also with respect to employees, right? Because many employees themselves are also very familiar, proficient with the means of communications that we're talking about. So we have to be careful about the employees, because the employees will many times feel it's normal to use their personal accounts to conduct advisory business. This is not necessarily new. I have been in other organizations where an advisor on his or her own may have actually purchased a newspaper advertising and promoted him or herself separately from the organization. But with social media, it's substantially easier. So it is going to be important to figure out, maybe forbidding is impossible, because frankly, you never have full control of what people can do in their personal laptop, but of controlling the use of personal accounts to conduct advisory business or sort of general financial business. And it's going to be important to train and test employees in this regard. In some cases, what you do, there's many ways of handling this. For example, in some cases, you will allow employees to use their personal advisory, their personal account, but then you have to have access to that in order to be able to monitor and check what is being said. So forbidding it completely may not be the most effective approach, but there are ways of controlling it. And of course, one thing to keep in mind is that any electronic communications are records. So you're going to have to keep track of those, and the responsibility will be on the advisor to make sure that, to the extent that any electronic means of communication are used, they are preserved in the appropriate manner. So moving on to the next slide. Because we're using social media, it is more difficult, right? I mean, I wouldn't say in a more person-to-person approach. Naturally, we all come to an office before social distancing. We all come to an office and we talk about your objectives. Our clients, what I have experienced, don't want to do that. They'd rather be biking in Marin County, and there's nothing I can do about that. They just don't want to talk. They would prefer, because many of them are used to interacting electronically, they prefer to give their information, and their expectation is that there's a system that actually will process that. It's a little bit a mentality that it's closer sometimes to gaming, and by that I don't mean gambling. I mean their expectation is that there's a process that will give them more information, and some of this ensues from from the lack of trust that many of the younger generation, lack of trust that many in the younger generation have with respect to traditional finances or financial organizations. They want to understand. It's going to be important, regardless of what they, of the clients, of what the client is looking for. It's going to be really important that we explain the strategy. Clients have to understand the strategy. If they don't understand the strategy, then that's problematic, and they have to understand the implications of granting discretion, and also, of course, the dangers associated with investment decisions, not only generally, but specifically with respect to the use of social media for these purposes. And so, broadly speaking, this is a challenge that we're going to have to address. And so you just need to keep that in mind. So going to the next slide, I apologize. I thought, yeah. So before we talk about RoboAdvisor, let me talk about relying on technology to provide investment advice, because technology, at the end of the day, technology is always. I don't know where it is yet. There's no, it's further down.
No.
Yeah, it's on. Okay, well. So let me just talk about this because it's really important. Technology is a tool, right? So technology replaces the table and the conference room, but it is a tool, and we have to use it in order to gather the information that is helpful to understand the client's objectives. And depending on the product, the advisor may need to give clients additional opportunities to furnish information. So that's the difficult task. So for example, we ask questions such as, if the market goes down 20%, what would you do? And so the idea here is to gauge in an electronic fashion, to gauge their reaction and include that in an electronic format so that we can actually use that information in order to better assess the risk that the client is willing to undertake. Because at the end of the day, no matter what, whether you're relying on technology or not, you always have the fiduciary obligation towards your client. So moving on to the next slide, Marianne, about robo-advisors. And I want to talk a little bit about robo-advisor because it's kind of the natural path for many of the younger clients who do not want to have constant interaction with an advisor, and because of their trust are very, very wary about fees and about hidden payments. And this is true not only in the advisor side. This is true, of course, in the broker-dealer, and everybody has seen the number of robo-brokers that have come up that are automated and provide investment brokering services as well. The robo-advisor, as everybody, it provides the discretionary asset management service to clients through online, and I wouldn't say algorithmic based, but I call them automated programs. And I draw the distinction between algorithmic and automated insofar as it's not a contingent coding as such, generally speaking. So yes, you classify clients into particular slots that relate to their journey as human beings, meaning how old they are, how many children they have, when do they want to retire, what are their objectives. And so all of that gives you a path that enables you to give the client a type of investment that is suitable for that client and that it's appropriate for that client, as opposed to an electronic format that says if the market goes up 10%, sell 4% of the portfolio. We don't do that. We are robo-advisors for the most part, and I can say this, if the robo-advisor or not, are really intended to provide a longer-term investment rather than a market reactionary investment. And some people will call that passive. I think that we could use that terminology, but not necessarily. Some people may disagree on the definition of passive. That is, in fact, how most robo-advisors comply with their fiduciary duty of care and loyalty. And in addition, of course, to putting the client in the right path, the advisor will monitor the risk that the client is undertaking. So, for example, periodically we'll go back to the client and we'll ask some of the questions that were asked before, so that the client can then give us some information in order to us on a periodical basis assess what risk the client is willing to take.
We have a question, Julius, which is sort of interesting. We put this section in talking about younger generation investors, but somebody is saying, what happens when you have a senior investor who wants to or is in a program without human interaction? Now, far be it from us to pigeonhole people and say that the older investor doesn't like technology and is cranky when it comes to technology. But if you have a senior investor, a senior client, are there any considerations in having that client be one of your robo clients?
Not at all. Look, so we have clients. In fact, we have clients that are over 100 years old. But this is not a service for all clients, and many clients, and we have clients that expect a more intensive relationship with the advisor, the more person-to-person relationship with the advisor, and we have a group of people who actually you can call, and when we perceive that that is the objective of the client, we have a conversation with the client. We explain that's not how we operate, and many clients just basically decide not to be our clients, and we understand that, and we're okay with that. Having said that, we don't lose the obligations of an advisor with respect to the care, even if the client is 100 years old. We have our list of red flags, and our list of red flags will hopefully identify when there is exploitation or there is another problem, and we do all these things that Joelle discussed, and we do reporting, and we do sometimes freeze the account temporarily in order to be able to contact a trusted contact. So. The robo system is self-selective in many ways. Many clients just don't like it, and that's because of the contact, but we don't lose the obligations that we have as an advisor, and we follow them as closely as we can and as closely as the law requires. I hope that answers the question.
Well, and if you remember in the Form CS and all the discussion around that, one of the fiduciary acts is making a recommendation or seeing that the type of account is in the client's best interest. So again, this would mean that if you're recommending that perhaps you wouldn't recommend a robo account to somebody where you know that person's investment style or objectives puts a value on handholding and personal information. But as you say, the robo is generally self-selecting. So do you find yourself making recommendations of robo, or do they just come to you?
So we don't make recommendations of robo per se, right? So our literature is very clear about what we provide and what we don't provide, and I think that's consistent with other robo advisors that I've seen. So we don't have people out there promoting the robo advisor. But our literature makes it clear that the type of service we provide, the literature describes the type of service, and in that regard is what I'm saying. That's what I mean by self-selecting. It's self-selective in many ways, not only because we provide the information, but because the way to access the system, the way to interact with the system requires a knowledge of technology that many clients just don't want to have, or they don't wish to be proficient. Our clients who are much older, and I count myself as one of those because I am substantially older than the average age of my client, they use technology. They're very proficient with technology, and they want to interact in a technological way. So there is that self-selection, but we're very wary of making sure that clients understand what they're getting into before they get into it. because what we don't want, and I think this is true for most robo-advisors, is disappointed clients. No one wins with a disappointed client. And a client who doesn't get what they want is not consistent with their fiduciary duty.
Well, and that's a great segue. We have 5 minutes. That's a great segue into the end of the life cycle of the client, and that is knowing when to part ways with the individual client. Nobody likes to end a relationship with a client. Nobody likes to drive business away, but at some point, in some cases, that is the most sensible and best thing to do. So do you ever part ways with your clients? Do you ever terminate your clients? Julius?
Yes. So let me start with the most obvious situation to part ways. So some clients engage in fraud. Some clients engage in violent behavior, or they are in a very aggressive behavior. That could be when they call our product specialists or the people on the phone, or when they email us. And so it is clear to me, and I don't think there's any problem, that when we detect that type of behavior, we end the relationship, and there are many instances when that happens. And those are the clear cases. In other situations where the style of the client and our style is different, we have a conversation with the client. And I think many clients, not many, but some clients make a determination that the system or the service we provide is not for them, and they part. In that case, we're not firing them, but there is a voluntary voluntary action by the client. It's difficult to get rid of clients. No one wants to get rid of clients, but again, the guiding principle in all of this is doing what's right for the client, and so. If a client requires hand-holding and a closer relationship, and we can't provide that because that's not part of our business model, we'd rather not have the relationship with that client. And most clients understand that, and they part voluntarily.
Okay. Well, I would just remind that when the situation arises that you are terminating a client or the client is terminating for you, keep in mind that the fiduciary obligations continue through the end of the relationship. You can't see the tape in the future and stop running. You have to get through the tape. So if you are terminating, you can't just walk away from the account. You need to give reasonable notice. You need to give them reasonable assistance in moving the account, whether transferring the assets to their bank or to another custodian. And you should make sure that you're not keeping any unearned advisory fees, and that you're returning what you didn't earn. And then obviously your record keeping obligations don't end with the client relationship. So you have to keep in mind that you need to maintain records typically for 5 years, sometimes 6 years.
And Marianne, let me just add. Okay, I just was going to add, this is really important as you wind down the investment. So it's not like when the client leaves, you just say, well, sell everything regardless of the impact on the client. You still have the obligation of winding down and liquidating assets in a way that is consistent with the best interest of the client.
Right. Thank you. We have 2 minutes left, so let's do just quick closing thoughts, the best takeaway sound bites that you have. David, I'll start with you.
Yeah, I think getting to know your clients well is obviously one aspect, a very important aspect in retail clients that as a firm, we collectively need to know our clients very, very well. We have 250 clients. And it does take a lot of time out of your day. And as Julius will know, I mean, it's when you got demanding clients, clients that maybe look difficult or need more hand-holding, it takes time. And so that's very important. I think the second thing is that with senior clients, as we talk about this, is, the age of 65, we've got some very good clients at age 80, 90 who have got their marbles still, pretty good. But we've got other clients who are under the age of 65 who are perhaps not having a good time. So I think the age thing is something you need to be aware of. Age sometimes doesn't really matter in this case. And I think the third thing is that, as we've seen, the regulatory environment is getting a lot more complex, and with respect to onboarding clients and getting all this information, you're going to have to spend a lot more time documenting and having your policies and procedures in place and making sure that all pans out. It's become more difficult. The one thing I would like to add is yesterday we were pressed on the panel. Joe and I were laughing because we both watched the same movie. For those of you who haven't seen it, it's on Netflix. This is not I'd say a recommendation, but there's a good movie called, what's it called again? I Care a Lot, right, Joelle?
Right.
I Care a Lot. So for those who are interested in this whole issue of senior clients and the whole issue of guardianship and exploitation, watch the movie. It's kind of a little scary, but it's interesting.
Okay, well, I see we have run out of time. We are at our 2:50 mark. We also got a number of questions in just in the last 2 minutes that we're not going to have time to answer. But you can reach out to us after this session is over if you'd like to follow up with any of this. And with that, I will thank my esteemed panel members. I hope we have supplied the audience with some food for thought and some takeaways. And I wish you all the best and have a wonderful weekend.